All right, numbers are climbing, so it looks like we'll go ahead and get started. Welcome, everyone. My name is Carly Gersberg. I'm the Program Manager for the Training Institute on Strangulation Prevention. Thank you so much for joining our webinar today. I just have a few housekeeping items before we begin. All attendees are automatically muted and your cameras are turned off. We will be sending out an email with a Dropbox link that will contain a copy of the recording of today's presentation, along with the slides and a certificate of attendance that you'll be able to download. If you'd like to send any questions to our speakers during today's presentation, you can click on the Q&A button at the bottom of your toolbar. And in your Zoom screen, you can type in your question and then hit send. We'll have a Q&A session at the end of the webinar, and we'll try to answer any questions that we get. And if you can also use the chat feature for any general discussion or to tell us who you are and say hello and where you're from. If you have any technical issues, please feel free to contact us in the chat feature, or you can also email us at institute@allianceforhope.com. And if you need to listen to the presentation on your phone, you can use the dial-in number here, and the webinar ID is also on your screen. It's 892-6649-6226. Thank you so much, and I'll now turn it over to our host for today, Gail Strack.
Well, thank you, Carly. It's very exciting to see so many people interested on this topic. So my name is Gail Strack. I'm the CEO and co-founder for Alliance for Hope International, and I get the honor and privilege to oversee the Training Institute. And I'm very excited about this topic for many different reasons. But before I go into a little bit more, let me just share a little background about myself. So this way I can put my comments into context, and then you can also know where it's coming from. I started my career as a public defender, handling many domestic violence cases. In fact, that is where I met Casey Gwynn, who is our president and also co-founder of the Alliance for Hope International. And then he convinced me to switch sides, and I became a prosecutor. Spent most of my legal career as a prosecutor handling domestic violence, child abuse, sexual assault, and elder abuse cases. And then I became the director of the San Diego Family Justice Center and saw things from a different perspective. And now my legal career really consists of handling a number of cases on the civil side, on the civil front. So I had the privilege to be able to see this issue in so many different ways. And I'm honored to be joined today by Mike Agnew. Mike Agnew is a retired detective from Fresno Police Department. He too has committed his career to this issue. He's also a post instructor. I like to say he's got a black belt in training police officers. And when I thought about this topic, I thought I have got to bring Mike in. He has dealt with this in the front lines. He has overseen so many other officers, trained officers, that I felt that together we could really give you a good perspective. He's also one of our advisors and faculty members for the Training Institute. He's been part of the journey from the very beginning in 2011. And when we kicked off the Training Institute, Mike Agnew was the top of my list to bring in and help guide us to vet all the materials that we're sharing. So we've got a lot to cover today. It's an important topic. It's a very complicated topic. And given all the people that have signed up, I suspect that we're all struggling with this issue. And the best way to struggle or deal with something you're struggling with is just to talk about it, to go to training. And I am hoping in today's chat, you will all stay very active and engaged. And you can start sharing by sharing some of the challenges that you are dealing with in your community. We have a multidisciplinary group, and I love when we have multidisciplinary professionals joining us because we get the perspective from everyone. You can also share with us your secrets to success. As you know, this is complicated, and there's just no one way to kind of figure this out except just doing the best that we possibly can with all the tools that we have. So before we go too deep, and I plan to start right away, is we need to start with gratitude. And I'm very grateful to the Office on Violence Against Women, and in particular, Nadine and Kevin, who have been at OVW for a very long time and have provided great leadership. And Kevin in particular is our program manager. So it's just fun to be able to work with people that you like and people who share your passion. And they're giving us this opportunity to share this topic with all of you. I also want to share my thanks and gratitude to our Institute team, from Carly, who's working behind the scenes, along with Grace, who recently joined us, Emma, who loves to work on so many different issues, including our newsletters and our new Hope Hub, Fernanda, who is translating everything into Spanish, and Yesenia, who's just a gifted graphic artist who makes all of our things, what we call Yesenia, pretty. As everyone knows who knows me about this topic, I started to do this work back in 1995 when two teenagers died under my watch, Cassandra Stewart and Tamara Smith, two teenagers, two young mothers who had both called the police to report they had been choked. And then within weeks, and in Tamara's case, within a month, both of these teenagers were murdered. Little did we know what we know now, that if you're strangled one time, you're 750% more likely to be killed by your abuser. So now we know that stranglers are dangerous. We know stranglers are connected to cop killers. They are identified as cop killers because if you look at the individuals who are in assaults and who are shooting and killing police officers, they tend to have a history of domestic violence, including strangulation. And if you look at the mass shooters in America, they too have a history of domestic violence and strangulation when you dig deep enough. So these individuals are different. These individuals are also very manipulative and cunning, and it is a weapon of choice. So today we plan to cover context. I'll be doing that in about 15 minutes or less, giving Mike Agnew the bulk of the time to walk you through all the factors that you need to consider and going through 2 case studies. And if we have enough time, I call it the bonus. We're going to cover some solutions. And if we start running short of time, which is fine, we will add those solutions into the chat feature and share the entire PowerPoint with you. So thank you so much for joining us. And I want to start by why are we here? And why are we here is that it is complicated. This issue has challenged me early on in my career. Not only in 1995 did the 2 teenagers die, but it was also in 1995 and 1996 that I started to realize, oh my gosh, I think we've got a problem here. So it goes back to Sergeant Ann Odell, who was a sergeant with the San Diego Police Department and a very good friend. She would dial me anytime there was an issue, and I made myself available to the DV detectives because we were all learning together, as we both had specialized units at the city attorney's office and a specialized unit at the police department. So we were a group of highly motivated, committed professionals who wanted to get this right. But Ann called me one day and said, Gail, we got a situation. We have a woman who's been arrested. She's now in the jail, on the hospital side of the jail, and she has signs of being strangled with a bruise behind her ear. She also is reporting symptoms, a raspy voice, difficulty swallowing. And then she went through the facts. And when she went through the facts, we both kind of realized that maybe we identified the wrong dominant aggressor. And we immediately released her from custody and then also made an appointment with each other to kind of talk about this case. But before we could have that meeting yet again, a number of cases were brought to my attention with respect of identifying the dominant aggressor. And in each one of these cases, I realized they were complicated and maybe we didn't get it right. But this was an opportunity to try to figure out, well, what's it going to take for all of us to do a better job? So that was the beginning. The next thing that ended up happening is I figured, well, let me just gather the intelligence here. What is happening in San Diego? What is happening in California? What is happening in other jurisdictions? And at the time I did my research, I realized the numbers that we've all been trained is that we were trained that 95% of the time, men are the ones who are going to be the aggressors, and 5% of the time, the females would be identified as the aggressor. And in San Diego in particular, to kind of figure what was happening, Casey and others from the San Diego Domestic Violence Council did a study reviewing 911 calls from children, and primarily the children had identified their stepfathers or fathers, the boyfriends, as the dominant aggressor, the perpetrator. And then an article came out right about that time, which said that in Los Angeles, they had identified 14.3% of females who were being arrested for domestic violence. And I'm going like, oh my gosh, what is happening in LA? And what is LA doing about this? Because certainly that's not happening in San Diego. So then I went to San Diego PD because they had a great analyst there. And I said, hey, Joe, what are our stats when it comes to females and males being arrested for domestic violence? And to my shock, we had 15.7%, which I thought, okay, we're higher than Los Angeles, and we've got all this specialization, the DV Council, all these wonderful protocols. So what is missing? Because obviously something is. Then I decided to take a look at our cases that were being submitted for prosecution by the police department, saw that we were rejecting a high number of cases. And I thought that's not good. That means we're not giving our police officers sufficient guidance on what to do with these cases. And the cases we did prosecute, to my surprise, we actually had a high conviction rate. And kind of like my preconceived notion is that these cases were going to be difficult. And then I thought back about a case I had just prosecuted involving a female defendant, and the male victim didn't even testify in court. We proved the case without his testimony, but at the time of sentencing, he was there. I started to kind of pull everything together and realize that there were the similar dynamics. Yes, females can be the aggressors. We also looked in this study of all the cases that had been prosecuted that year. They kind of fell into different categories. They were batterers, just like male perpetrators. We found that some of them were standing up. It wasn't a legal defense, but they were standing up for themselves. I felt in some cases that they were being set up because there was a history of prior domestic violence and threats that next time you're going to get arrested. And I thought in another category, there were some mental health issues. And in the last court category, I felt that maybe we did not identify the true dominant aggressor. So overall, in our research that I was able to find for California, on average, we were about 14 to 15%. So the next question you have to ask yourself when you're dealing with all of this and trying to unpack, how did we get here? I realized, why was this happening? First of all, could this be a backlash from all the pro-arrest policies and laws that were happening? Did we have sufficient training, not only at the police academy, but what did our dispatchers need to know? And what about the prosecutors? I mean, you can just go right down the list. And then what about attitudes? Is this just because San Diego had some bad attitudes towards women? Is this complicated? How much time did our police officers have to sort this out? And one of the things that we did in San Diego is that we always encouraged our prosecutors in the DV unit to go on ride-alongs with police officers, because as you know, back then and even still today, there's not a lot of training on how to sort all of this out. So we felt that the best training is to be right there with the patrol officers and the DV detectives as much as possible, and we can learn from each other. And that's what I'm hoping today, that we can learn from you as well as you engage in the chat. And then of course, are women violent too? And I think everybody would agree the answer is yes. And then because I was a public defender, I realized that a lot of training and education was going on right in the jail and also at Batterer's programs. So a couple of other things that I think are important to understand, especially if you're new to this work, is that there has been a long history to get us to where we are today. First and foremost, I'm not going to go back into the 1800s, but we'll just stick in the 1900s. Back in 1980s, there was a time where we didn't have any pro-arrest policies. In fact, the policy was to not arrest, and for police officers essentially to be social workers at the time. The problem with that solution is that we had the highest rate of domestic violence homicides because we were not intervening early. And then lawsuits started to happen because many victims needed the help from police. And one of the most probably well-known case is the Tracy Thurman case, where they won that lawsuit against the city of Thorrington, Connecticut. And that caused a lot of awareness and attention and thinking and policies and protocols and research. And in the research, they tried to study, well, what is going to be effective? And a number of studies came out initially, which said that the arrests were a good deterrent to domestic violence, continuing over and over again. So that led to some new laws, new policies, where some jurisdictions had pro-arrest, preferred arrest, or mandatory arrests. And then after that, we started to see, because when you pass these laws and you don't have training and education to go along with it, you have to kind of figure it out on your own. And figuring it out on your own is not a good thing unless you have champions in your community who are getting ahead of this with putting together protocols. So we started to see more women being arrested. And to kind of fix that problem, we started to pass primary, predominant, dominant, aggressor laws to try to solve that and prevent dual arrests. Well, as you can imagine, with all of this happening within a relatively short period of time and a lot of turnover, it became overwhelming and confusing. And that was one of the things I discovered when I went on a ride along that year and asked police officers and patrol officers how they were trained, how do they identify the dominant aggressors. And I did the same thing with judges. I did the same thing with prosecutors and advocates. And it was really quite clear that everybody was looking at this from different perspectives, which is a good thing, but can also be a challenging thing. And then at the end of the day, OVW came out with some guidelines because they started to realize that this was happening. And in order to receive funding from OVW, you needed to make sure and demonstrate that your laws, your policy, and your practice and your training programs were all geared to figuring this out. And they even attached a lot of funds for training at the time. Unfortunately, if you kind of think about it, and I thought about this yesterday as I was preparing yet again for this webinar, is that I don't remember the last time I've been to a conference where this topic was being included on the overall agenda. We try to include, in fact, we do include this topic in each and every one of our trainings, but I felt we too could add more and do more. So overall, I'm not going to go through all of the studies that have been written on this topic, especially when it was like a big issue across the United States. And I still think it's a big issue across the United States, but we need to pay more attention to it. So overall, the studies corroborate, yes, more women had been arrested. Yes, dual arrests were occurring in some jurisdictions up to 20%. And if you are a jurisdiction where you're seeing females being arrested 30, 35%, or dual arrests at 20%, I encourage you to kind of bring back the team. I call it, let's get the band back together again. Let's get a multidisciplinary group back together again, and let's analyze what is happening in our community, because those numbers are high. And there is a consensus that with respect to pro arrests and preferred arrests and mandatory arrests, that it's going to get officers into a certain line of thinking. So the training is key, and understanding that officers still have probable cause to arrest, and they still have discretion to arrest because they are the judge of credibility, and there's case law to support that. And last but not least, there is complete consensus that when it comes to identification of the dominant aggressor, that we all need this training and we need adequate laws. So let's talk about the adequate laws. The last time I did some research and I tried to update this, so we have about 35 states that have some type of dominant, primary, or predominant aggressor law. Connecticut was the state that has passed their law most recently, and I reread it It's very comprehensive, and I would encourage you to take a look at it, because one of the recommendations I'm going to make to all of us, including California, Mike, and I'm going to need your help, is what can we do to improve our predominant dominant aggressor law in California? Because what the studies have shown is that if you are a state that does have this law, you are ahead of the game. Because in the research articles I read, these are the states that tend to have lower females being arrested and lower dual arrests. And if you are anywhere, I would say over 5% in your dual arrest rate, you've got something to reconsider. So now strangulation. What about strangulation that makes it even more difficult in a domestic violence case to identify who is the dominant aggressor? And I'm going to use dominant aggressor because both Mike and I like that word out of all the different phrases being used across the United States. First and foremost, one of the first challenges I realize is that because of a lack of oxygen to the brain, the victim may not remember, and because she has been traumatized, the information she's sharing to police officers may be all jumbled up. The other issue is that we're realizing is that a lack of oxygen to the brain causes you to be more combative, because you, as you were passing out, were probably fighting for your dear life. You couldn't breathe, you're terrorized, you are in a panic. And when you come to right where you left off. So that's a challenge. The next challenge is that what we've learned in the research is that when you think you're going to die, you're going to defend yourself. And in strangulation cases, many of our victims, at least 50% of the time in the study that we did back in San Diego and the subsequent studies that have happened since, you may not have any visible injuries, especially at that time. So the third big challenge is that most of our victims do not seek medical attention. So the true extent of her internal injury, since most of the injuries are going to be internal, may not be known. So the last and final challenge is that most likely, and two studies that I have found in the Wilbur study, in 2001, where they interviewed victims who had been strangled. They were survivors that they identified from a shelter, and those who sought medical attention, and those who generally were at high risk. 70% of them thought that they were going to die. And in the article written by Susan Sorensen and her colleagues, in a more qualitative interview process and research process, 100% of those survivors believe that they were going to die. So if you are at that stage, you can also anticipate, if you're terrified that your abuser is going to kill you, you're not going to be cooperative, as we have always called victims. They're either cooperative or uncooperative. I would just say, let's replace the word uncooperative with terrified, with fearful, because of their circumstances. And as I kind of wrap this up and give this to Mike, I just want to highlight a couple of other things. So what is the prevalence? How often are you going to see strangulation cases as you respond to this? And I've got research from different disciplines and in different environments. Right now in California, we're just starting to gather these statistics about how many cases involve strangulation and suffocation, because it was in 2017 that we passed a new law in California, which all of you, I think, should consider, is that in California, when police officers respond to a call of domestic violence and they find out a victim has been strangled, they actually have a legal mandate and duty to warn the victim that this is a lethal situation, that she may have internal injuries, that she should seek medical attention, and that she should talk to an advocate. And we also have a duty to track. So this way police officers know who they're dealing with when they respond to DV calls. Unfortunately, this is all new. And both Mike and I believe that 5% is extremely low. We think it probably should be around the 15% mark, but it's a start. And I think that's another key point, is start keeping track of your stats. I try to look at state stats, national stats, and let me tell you, that was quite a workout. I do know that from the work that Jackie Campbell has done in all of her articles, nationwide, we're looking at about 10% of all the population where they've experienced strangulation. But when you get to police reports, and I'm talking about all the DV calls that you're going to get, and you got your report on domestic violence, how often will you see strangulation in those circumstances? And it's about 15%. We know that from the unpublished article from Mike Agnew, who did his own study. The only published one that has been peer reviewed would be the Pritchard article of 2016. And then Minnesota, when they passed their law, they did an informal study as well, all pretty consistent. Now, when you get to family justice centers, we're finding higher numbers there, and it makes sense. The victims who need assistance, who are going to be at high risk, are the ones who are going to be calling the police. And that's what we're seeing in the Oklahoma study of 2018. 80% of those victims who called the police, where officers used their risk assessment protocol, identified that the strangled victim was the high risk victim. And I think all of you who are on this call know that. So the other thing I want to share with you is anticipate self-defense. Number one, as a defense attorney, I always would bring up the self-defense, because if you have denial, and then if you have some evidence that you were there and some admission, then the next defense was always self-defense. And as a prosecutor, I saw denial and self-defense, the top two things. So going into this, anticipating that self-defense is going to come up not only in domestic violence cases, but strangulation cases is going to be key. Okay, so how else do we know this? This is a great survey that was done by the Maine Coalition on Domestic Violence. They did it with batterers programs, and they asked batterers about strangulation. And what was interesting to me is that they asked the batterers themselves, the person who was doing the harm, is did the victim scratch, kick, injure you in some way as she was trying to defend herself? And I will stop here and say, as you know, when it comes to strangulation, strangulation is a gender crime. Every study has backed this up. When it comes to domestic violence, men are the ones who are strangling their partners. Females do strangle men. It is extremely rare. We see it more in child abuse cases and elder abuse cases than we do with women strangling male partners. So 31% admitted to self-defense. And now let's go to my first case when I was prosecuting and now figured out, oh my gosh, we need to go forward on these cases, even though both parties may have visible injuries. So this is our victim who was strangled. She had an abrasion underneath her chin, but her boyfriend had scratch marks to his face, to his hands, to his shoulder area. And I was lucky enough to find an article from 1981. I love this article, reread this article for yet the third time. It's one of my favorites. It's interesting that the author's name was harm as you think about the harm that is being done. But what was like so fascinating about this article is that forensic scientists, forensic examiners really went back and looked at homicide cases and non-fatal strangulation. They worked very hard to pull sexual assault cases and intimate partner cases. Back then in 1981, they called stranglers throttlers. But what they identified is that the abuser, the attacker, the strangler had visible injuries, mostly to the hands, to the wrist, and the forearm. As you can imagine, if they were approaching them with two hands and you're trying to breathe, trying to take pressure off your neck, trying to stay alive, where would you find these injuries? And I think it also makes a business case of taking photographs of both individuals when you're trying to identify who is the dominant aggressor. I'm going to make one more point from this article that I found extremely interesting, is that in the sexual assault cases, the rapist had visible injuries from self-defense where the victim was defending herself essentially all over the body. But when it came to strangulation, their injuries were really limited to the face, the shoulder, the hands, the wrists, and the arms. So something to, I think, to use, because this is from a scientific standpoint. That was another article, peer reviewed. So last but not least, I think I also learned so much from Dr. Dean Hawley, who, as many of you know, was part of our original team of mentors. And he was a pathologist, and he handled thousands of autopsy cases. And he was one of the first ones to tell us to anticipate and look for those scratch marks on offenders. And then now I'm collecting cases where other experts are testifying in court that it's common for defendants to have injuries by the person trying to resist them. With all that being said, I'm going to now switch gears and invite Mike Agnew to join us. I'm going to stop sharing, and then hopefully we can switch very quickly and easily. Hi, Mike. How's it going?
Good, good. Glad to be here.
Well, and I know how much you love Zoom and all of these new things we've had to do as we have pivoted this last year during COVID. But I really appreciate you joining us and leaning into Zoom. So what I'm going to do now is take a look at the chat, start gathering some of the challenges and some of the success that people have had, and addressing some of the questions as you are now going to take on the bulk of this presentation. And thank you, Mike, for being here and sharing all of your expertise and what you share with others as you do this training, like all the time.
All right. Thank you, Gail. And thanks for helping with the questions when they come in, because I know those are important. So we have a poll question, and let me just confirm that, yeah, they're popped up. We're looking for who our audience is this morning to see kind of the direction we want to go here. But just to kind of emphasize my background so you know where I'm coming from when I talk about this, is I was a sworn officer here in Fresno, California for 38 years. But what's significant is the last 15 years of my career that I was the lead detective in our domestic violence unit, which basically consisted of 10 detectives that did nothing but follow up on domestic violence reports. Because of all of this, I would have the opportunity, and I still have the opportunity, to train law enforcement officers in domestic violence investigation. The good news is when I teach dominant aggressor, and I go back 10 years ago, we would use scenarios and ask the officers in training to identify the dominant aggressor. And they would miss it most of the time because they weren't looking at the big picture. Today, when I throw that same scenario out there to newer officers who are just starting work, but they are on the street handling calls, they are getting it right about 90% of the time. So I think we're headed in the right direction here. Looks like the majority of our attendees are going to be advocates, which are super, super important in domestic violence, because we can't do it alone as law enforcement. We need to have that other part out there helping us. Our department used nonprofit victim advocates who were housed with us in the office. And when we went out to see victims for follow-up, I would take my advocate, Katie, with me, and together we would work with victims not only to build the case, but to provide the resources that they do need here. In California, actually, when they first gave us the domestic violence laws, I was out there on the street, so it was new for us. And I will tell you that all we did was look for injuries, and we would determine who was dominant, looking at injuries, and make that arrest. So what would happen is if we had both parties with arrest, it was really simple to simply make a dual arrest. California used to have the law called primary aggressor, and that was not the intent of the law. So California actually changed the terminology from primary to dominant. And I know different states use different terms, but I really believe we're all looking at the same issue here on who is dominant. So that's what I want to walk through. So welcome to law enforcement, medical, advocacy, and probation paroles here. Good. And we've got some pretty good number of others out there too. So I'm glad you're all here, and I look forward to my little part here that we're going to be working on. And it's not. There we go. So I'm going to share things that I have learned from other presenters at conferences. And one of the most amazing presenters I found, Lieutenant Mark Wynn, and I say amazing because, like me, he was law enforcement. But Mark really made an excellent point that domestic violence is not just the one incident that we are looking at or that we're responding to as a law enforcement officer, or that somebody's coming in for services. There is really a history behind it. It is more like a course of conduct. We have to look at what has happened out there in the past. And that may be a police report in the past, and most of the times it's not a police report. It is simply an incident that involved violence and it involved fear. And that has a lot to do with why people are doing what they're doing in the most recent case. So looking at the history is an important part of law enforcement investigation. Another person that really had a powerful impact on me was Ellen Pence, who was back from Duluth, Minnesota, and is actually one of the originators of the power and control wheel. But I'm sharing with you what she said at a conference. And it's not always as simple as one person having power and control over another, with the aggressor being the only person using physical force. So if we keep that in mind, most of our people who are being attacked are doing something. So it's one person trying to exert power and control over the other and with force, and the other is using force to fight back or simply to escape. And it's that action that's causing injuries to both parties. And if we come in and just go, both people have injuries, we're arresting you both because we believe you were both attacking each other, we're really reinforcing the batterer's statement that I told you so. And this is all part of their power and control dynamic that plays a huge role in all of our domestic assault cases. If you think about the dynamics here that a batterer uses to control their victim within the circle, a lot of these forces here have an influence on what a victim does during the incident here. If you think about if there's prior threats, if there's coercion, if there's intimidation, if there's prior physical violence, that plays a role in how a victim responds to what the abuser is doing to them at the time. And today, I'm going to ask you just to think, what is the most powerful segment of the power and control wheel today being used by abusers against their victim? And when I say today, I'm talking about the past year, because what we see is that our victims are now more isolated than ever before, which really reduces the ability to get support, to get services, to escape. So I think that segment has really become much more powerful. So like I said earlier, California changed it from primary because a lot of officers thought it was, well, it's who starts it. And that probably goes back to a lot of things, way back to our childhood when our parents wanted to know, well, who started this thing? And that's not what we're looking for. The dominant aggressor is the person determined to be the most significant rather than the first aggressor. And that's the penal code section from California. So officers know this, that it's not the person that starts it. They may be the dominant aggressor, but that's not the only thing that we look at. Some people like to think of mutual combat. I'm going to put up here the jury instructions for mutual combat and think about our domestic violence couples involved in a fight and think about, does their fight match this definition? A fight is mutual combat when it began or continued by mutual consent or agreement. and that agreement may be expressly stated or implied. And that's really not what happens in our domestic violence incidences where people are fighting. It's really a matter of who is dominant, who is creating fear, which party is in fear, whose actions are more significant against the other. And always think about who needs protection in this relationship. Again, it's not who started it. So what I'm interested in hearing from you is an answer to this question here, because there are lots and lots of factors to consider when we're speaking with both parties and trying to determine who is the dominant aggressor. So if you could pick out one, I've only given you 5. If you could pick out one of those 5, and let me know what we think here. Ooh, wow. Powerful number there. Almost 80% want to look at injuries. Good call on size of the parties, because a smaller person can be the dominant. Use of weapons can be very, very significant. I'm impressed. Because that is something we do look at. Excellent. I'm going to say you all passed that quiz question. So that takes us to the big issue of, I'm trying to advance my screen here. There we go. That's the one you picked, and believe it or not, that was there before you took the poll. But that's what people tend to look at, is the injuries. And so what I want to do is walk you through some of these, a case here involving strangulation. And as Gail had mentioned earlier, there's some issues to think about, though, when we're looking at strangulation cases, because they are unique. So we know that strangulation assaults don't always result in visible injuries that we can see. In fact, pretty much about half of our cases have no injuries that we can see, or a lot of our cases actually beyond that have injuries that are so minor, they don't even show up very well in the photographs that we take with our sophisticated digital cameras. So we have very minor visible injuries from a strangulation victim. So what we look at next is the symptomology. What is the victim expressing? And they're not probably going to volunteer symptoms of an internal injury unless we ask specific questions. So these can get missed very easily in our strangulation cases. Or while we're out talking with the parties, they may not even have the symptomology yet because the swelling hasn't reached that point, or the injury hasn't reached that point where they're experiencing a symptom of an internal injury. So we just might be missing what's going on as to the level of injury to our strangulation victim. So I want to walk you through, this is an actual case here that I was involved with as the detective. And the first call that comes into 911 is a hang-up call from a home. And before the officers can arrive at that residence, a second call comes in. And this is the neighbor right next door who's calling in, reporting that there's a female being attacked on their front porch. So here's our male. This is the husband, and he is in the emergency department. And he has very, very significant injuries with several stab wounds to the head and to the side of his left eye. And then we look at the scissors that were used on the husband by the female. So we basically have a weapon involved. We have very significant injuries to him. And here is the wife, and these are her injury photographs. And they are not as significant as we would like to see if we're going to be determining that she is the victim. And here's the necklace that she did have on her neck. You can see that it was broken during the assault. And if you go back and look at the, back up, you can see some of the marks on the neck were actually caused by the necklace rubbing on her neck. So people want to know, well, how do I determine who is dominant? So things to look for: witnesses. Who are the witnesses and what did they see? And this may well include people that are not there, but they were there at the time and have left. They may have actually, the victim may have actually even called or texted people after the assault. And those people are witnesses because they heard the victim talk about what had happened. What's the physical evidence? Does it support what's being said, or does it not support what's being said? 911 is one thing to look at. Just because they're the first caller doesn't mean they're the victim. But we need to look at what's being said on the phone, what's the demeanor of the parties. If we have the ability to listen to those calls, or at least have the complaint taker share with us what was being said. The history is probably one of the most important things by both people. What's happened in the past by them. And if you're thinking about really digging into history, one of the best tools to use after you get them to narrate to your open-ended questions about the past, actually you can go into these lethality assessment forms and ask questions about, have they ever threatened you in the past? Have they ever hurt you in the past? Have they ever used a weapon against you? And you can really actually many times find other crimes that have happened in the past that were not reported by the parties involved. And then you're going to get detailed statements by both parties about what took place to help us determine who is dominant. And the biggest issue is the self-defense issue. Was one party defending themselves by using physical force against the other, and it did result in injuries to the other party? So let's think about self-defense. What's involved in self-defense here? And if you're acting in a lawful manner, you're not involved in criminal conduct, you're just simply a partner in a relationship, and you're involved in some type of disturbance, and you have a belief that a bodily injury is about to be inflicted. And the reality is the bodily injury can be minor or it can be very serious, all the way to fear of death, but it can be minor. And the threat against you is imminent. It's something that's happening right now. And the level of force you use is reasonable as self-defense, then it's going to be a self-defense issue. And there should not be an arrest by somebody that uses physical force against another, as long as their force they used was reasonable to stop or prevent an assault, where you had a belief that you were going to be injured. And I think the biggest thing there is that it has to be reasonable. This is the California jury instructions on self-defense when that issue comes up in court. And I think the biggest part is it must be reasonable. And we're going to come back to this question here about what type of self-defense is going to be used as I share this case with you. So I'm going to give you the facts of the case here for Alicia. And so Alicia is married 4 years. Okay, the female is found in front of the neighbor's home where that second 911 call came in. and she presents with several minor marks and abrasions on her neck. The victim reports she's been married to the suspect for 4 years, and they have no children in common. She has 2 children of her own from a prior relationship, ages 6 and 8. So she relates 2 prior domestic violence incidences with no police contact made. So there's your history. She reports that they are in the process of separating. Last night, after arguing, she left the home with her children and went to stay with a friend, Sandy. While there, the suspect called her cell phone and wanted her to come back home. They argued and she declined to return. On the next day, which is the date of the incident, she and her friend Sandy drove the children to the daycare center, and her and Sandy spent the day together. Later in the afternoon, they returned to the daycare to pick up the children. On arriving at the daycare center, our abuser, the suspect, who was drunk, ran up and began yelling at her about who she was having an affair with. She got the suspect to get into her car. Since he was creating a disturbance, a scene at the daycare center, she was becoming very embarrassed about his behavior. So the victim drove back to her home with Sandy and the 2 children and our suspect. She had Sandy take the car and her 2 children to Sandy's home, and she and her husband entered the home. Upon walking into the home, he began yelling at her, threatening to kill her, and she pushed him to push him away, and she went into the bedroom to call 911. The suspect followed her into the bedroom, and he pulled the cord from the phone, ending that call to 911. He then grabbed her by the neck and threw her onto the bed where he began strangling her with both hands around the neck. She describes they tussled, and that's her word, until they rolled off the bed onto the floor. He grabbed her head on the floor and slammed her head into the floor several times. He then grabbed her neck for a second time and began strangling her. She grabbed one of her clogged shoes that she could see under the bed that they were laying next to, and she began to hit him with the shoe, but the strangling continued. She then grabbed a pair of scissors that had fallen off the dresser during the struggle and stabbed him several times. She could not give details on how or where she strangled him. Now, at first thought, we might be thinking, well, she's not being truthful, but the reality is she's in that fight and flight mode, and so her brain is probably not storing the memories in detail of what was going on. So that makes total sense. She said that she stabbed him because he was choking her, and that's her word, choking. And he said he was going to kill her. She then broke free and ran outside to the neighbors on the right side of her home, but she got no answer at that door. She ran out into the street and tried to flag down a car driving by, but they kept driving. She ran to the neighbors on the left side of her home, and he tackled her and started strangling her a 3rd time. And she actually had carried the scissors with her the whole time, and she stabbed him again as they were on the front porch of the neighbor's home. The neighbors came out with the woman and her adult grandson, and they both began yelling at the suspect, who then stopped the assault, and he got up and began walking down the street. The officers arrived on scene. They found the victim on the front porch, and they found the suspect actually walking in the roadway, bleeding profusely from the head, and they described him as being very intoxicated. He was walking from a friend's house about a block away, and when they asked him what happened, he said that his wife was having an affair. So keep in mind, his first statement to law enforcement was that his wife was having an affair. The officers then asked about the injury, and he replied that his wife had stabbed him. So he was transported by ambulance to the hospital due to his injuries, and he could really not provide much detail. And the doctors advised that he had multiple stab wounds and might lose his eye. And the victim was transported to the hospital where she was treated and released. So if we look at our self-defense issue, was the level of force Alicia used reasonable? And what type of force used by her husband was Alicia trying to overcome? So the type of force her husband was using against her was deadly force. And basically, he was trying to kill her. So what type of force can you use that's reasonable to stop deadly force? So using the scissors was appropriate in that case there. You can also be defending other people or other things and not just self-defense. So when you think of defense of others, you can cause injuries to other people as long as it's reasonable. And so the cases that I encountered quite often were the intoxicated parent trying to remove an infant from the home or the house, or wants to put the infant in the car and drive away. And the other parent, who is not intoxicated, is trying to stop this person in protection of the child. As long as the things they do are reasonable to stop that person, it's going to be a defense of others issue. You can use reasonable force to eject a trespasser. So if somebody's trying to force their way into your home, and it's happening right now, as long as the force you use is reasonable to keep the person out, then that would be a self-defense issue. And you can use defense of property. So in this case here, one party is using a key to key their partner's car. The partner sees the keying in progress and actually goes over and grabs that person and attempting to stop the keying of the car. And the grab was of such force that it would left a bruise to the suspect's arm. That bruise would not be considered an unlawful assault as long as it was a reasonable amount of force being applied. Now, obviously, you couldn't come out to that person and start beating them with a baseball bat. That would not be reasonable. So I want you to hear Alicia on her callback just to support this issue of Alicia's level of fear here. Dispatch is calling the home back.
Hello. Hello. Hi, this is the police department. You've already called us? Yeah, where are they? My husband tried to kill me. What was that? Where are the police? Hey, they're on their way. Who's this? Who's this? This is Alicia. What? My name is Alicia. I'm scared he's going to come back or get my kids that are down the street. Okay, Alicia, you're the one that he was chasing? Yeah. Okay, who is the guy? Are you injured? Yes. What happened to you? I don't know. He was just choking me and he pulled my necklace off of my neck. He was pounding my head on the floor. Okay, do you need an ambulance there? Yeah. Yes? And he was choking me. He told me he wanted me dead. He told me he wanted me dead. Okay, stay on the phone, okay? I'm going to transfer you over to the ambulance, all right? What's your husband's name? Okay, is the blood on him? Is that from you or is that from him? From him. There were some scissors on the dresser. Did you stab him? Yes, several times. I fear my life. Okay. I just asked him to go. Okay, Alicia? I asked him to go. Alicia, let's keep you on the phone, okay? Oh, my God. Why? Okay, Alicia, where are your children at? Well, down the street at my son. Do you know the address? 40? Yeah. Okay, your friend is with the kids? My son has money.
So I've highlighted the things in that callback to the victim. And what you hear there is she's afraid that he's going to kill her. She's afraid for her children. She describes a strangulation assault. She describes a traumatic injury to her head from being pounded into the floor. She does want an ambulance, which doesn't happen a lot of times for our strangulation callers, where they don't want an ambulance. And I'm kind of wondering if her yes response to that was actually because she knew he was bleeding profusely from the head. But she does say that he wanted her dead. So in her mind, she felt like he was going to kill her. And she states at the end when the dispatcher asked her that she was in fear of her life. And that's her quote, "Fear of my life," is the way she said it. So if you think about it and look at her injuries and you look at his injuries, it's really not consistent with thinking about whoever has the most serious injuries is going to be the victim, because he was the dominant aggressor because of his attempt to kill. And so when we did a follow-up with Alicia 2 days later, she shared with me that her thoughts at the time, what she was thinking about, which is one of my questions, she thought that she was going to die, and her words were, "in this bedroom." And she began to cry 2 days later as she related to me about who was going to take care of her 6 and 8-year-old children, knowing that she was going to die there in that room. She also shared with me that she had urinated, which she was not aware of when it happened, and in fact wasn't even aware when the officers were there that she had urinated until somebody pointed out and asked why her pants were wet. So that's a strong indication that Alicia had been unconscious. If you'd asked her if she was unconscious, she would have shared that she had not been. But the fact that she didn't know when it happened is a strong indicator that the unconsciousness occurred during the strangulation incident. So there's other factors to think about when we're trying to determine dominant aggressor here. And you guys, that size of the parties can be a factor, but it's not always the indicator. A smaller person can be the most aggressive. Here, the use of a weapon, as long as it's not reasonable, would be an issue here. Alicia used a weapon, but the fact that she used the scissors, and actually she kind of went through a lesser lethal weapon first with the shoe, which did not work, and her only other option was to grab the scissors. Her husband was a stronger person. She was afraid of him, and she had been trying to separate from him for quite some time. And he was the type of person that was not going to allow that to happen. So she really was afraid of him. And there were 2 prior incidences of domestic violence unreported. He poses the most danger. He's using the strangulation against her, which Gail pointed out is 750 times more likely that he will kill her in the future. He did have the more serious injuries, but again, her injuries would have been fatal if she had not used the scissors against him. We can look at location and nature of the injuries, which we just did. Escalating the level of violence. So that's an example of where somebody pushes someone, and so there's the violence of the push, and then the other person responds with a severe beating, and so they've escalated it beyond of what it was supposed to be. And if one party has special training in some type of fighting technique, then that might be a factor to look at too. When we talk to the people and ask them what happened and ask them questions about what they were thinking about and what they were feeling and the reasons they did certain things, we look at the demeanor of the parties and how much detail they provide to us. Although keep in mind, a strangulation victim is probably not going to come across as giving you a chronological, detailed story about what happened. Especially if they've lost consciousness, they've been without oxygen to the brain, they're going to be responding differently to your questions and somebody that did not suffer that type of assault? Is somebody under the influence of alcohol and drugs, which has to go to credibility of statements? And we look at criminal history and we look at domestic violence history. And again, it may not be a reported domestic violence history from the past. If somebody has a restraining order or applied for a restraining order, that's a strong indicator that somebody is the party that's in fear. They're seeking protection from the other party. And interesting, there's actually factors that we should not think about, that we should not consider really to make our decision here. So we've had officers say, well, we can't arrest this person because they need to stay here and take care of the children. And that's really not something we should be thinking about. If they are the dominant aggressor, then they need to be arrested. And then we can think about other family members coming in for child care, whatever your department policies are. The fact that this arrest may not result in a conviction should not really be a consideration. If you have probable cause to believe that an unlawful assault occurred and this person is dominant, we need to make the arrest, even though we know the other party's actions may cause the prosecutor to not want to file a charge. We need to follow that probable cause issue here. The marital status may be one of the elements that you need in your state to make a domestic violence arrest, but we shouldn't be thinking about, well, if they weren't married, we'd make the arrest, but if they're married, we're going to make the arrest, or vice versa. Parties promising that everything is calmed down and they're going to stop the violence and one party's going to leave and there'll be no further calls. That should not be an issue. If we have probable cause to believe there was an unlawful assault, we need to make the arrest. Living on the premises, even if somebody's living there and the other person does not live there, we may have to arrest the person that lives there as the dominant aggressor and not use that as a factor. The fact that we need to make an arrest may cause somebody to lose their job. It's not something we can consider when we're determining a dominant aggressor. Our person who's not dominant does not want to prosecute, does not want to go to court, depending on the level of crime and your department's policies. That shouldn't be a factor on what the victim wants to happen. Remember that the whole goal is to take responsibility of prosecution away from the victim. It falls on your prosecutor's office. And if an incident occurred in the home versus public, it shouldn't matter either way where it occurred. If you have the unlawful assault, we need to make that arrest there. So the question really should be, do we have probable cause, or some jurisdictions call it reasonable cause, to arrest for an unlawful assault committed by somebody? We should not make an arrest solely because someone in a domestic violence relationship has an injury and we cannot determine how it occurred. If we don't have probable cause, we should not be making an arrest. So we do go to calls that are like loud disturbances, and when the officers enter the home and separate the people and find out what happened, and we see a bruise on somebody, and nobody will tell us anything about a physical assault, we have a gut feeling that there probably was, but we haven't reached a level of probable cause, and we should not be making an arrest. So we need to figure out some way to make sure that the violence doesn't continue, but we probably wouldn't have enough to make the arrest. And we should never arrest both people just because we can't figure it out. And so when we have both people with injuries, we don't know what's going on, and we make a dual arrest and thinking the DA will figure it out or the prosecutor will figure it out. That's not a reality. In my position as a domestic violence detective, I would continually get phone calls from patrol officers on the street wanting to, in their words, run this by me. And so they would give me what's happening out there and what the parties are saying. And they want me to answer the question about who should be arrested. And you really are in a worse position at a desk reading a report or listening to somebody tell you about it than if you are at a scene talking to both people, person to person, and looking at the scene and looking at evidence, that person's in a better position to make that arrest than we are. My typical responses were, well, here's some more questions to ask, and let them try and figure it out that way. But prosecutors typically, they share with me that if the patrol officer can't figure it out, then the prosecutor's not going to make a decision from their desk. So what happens when we do arrest both people? And I'm not here to tell you, you cannot arrest both people. In California, we're still allowed to arrest both people, but we shall try and determine a dominant aggressor. So I think my message is follow your agency policy if that's your role as to arrest or not arrest. But when we do arrest both people, because we had probable cause to believe they were both unlawfully assaulting each other and there was no dominant, most prosecutors are not going to file a criminal charge against either party. So the case is not going to go anywhere in the court system. And that may be a reality. It's not something that we should really think about. We just need to be aware of that's what's going to happen. If a true victim was arrested in a dual arrest situation, this incident will cause them to be less likely to call law enforcement for help in the future. And again, they're basically, the arrest is going to reinforce the batter's threat that they're just going to arrest you. If the children were involved, they may have been needlessly placed with either Child Protective Services or with other parties where there should not have been a dual arrest. They should have identified a dominant aggressor. And lastly, we've reinforced that batter's threat that the police are going to arrest the victim. There's a term called the sophisticated batterer, and I think that's giving them way too much credit. So I've actually changed that sophisticated batterer term to the experienced batterer. They've been through the system. They know how the system works. And so we see things from them because of their experience. And so what they've learned is that you really got to stop striking the victim where you leave visible injuries. And so they tend to hit the victim in the head, in the hair, where they know they're not going to leave the bruising that we can see. They tend to assault the victim in private areas of their body that they feel like the victim won't want to show law enforcement. Or they strangle the victim in a way that they know that they're not going to leave an injury to the victim's neck. And that's very easy to do depending on the type of hold that you use. So if you're using an arm around the neck, you're basically spreading out the force of that pressure over a broad surface area, and you're less likely to leave a visible injury with that type of hold here. These experienced batters, they may be the person that calls 911 first. So again, that's not the best indicator as to who is the dominant aggressor, but they may call first. They're going to destroy evidence before law enforcement arrives because based on their experience, they know what law enforcement is looking for. This is especially true when you're looking at law enforcement involved domestic violence, where your abuser is law enforcement. They know what the officers are going to be looking for, and they're the ones that are getting rid of that. They will intimidate the victim afterwards, but they're more careful now not to leave voice messages or text messages that we used to use all the time against them because of these intimidating messages, but they will intimidate in more subtle ways to get the victim to try and drop the case. And what I found is that they don't take responsibility for what they did. It's always the victim's fault, and they're blaming the victim. And actually, when you interview the abuser, they will do the same thing and tell you that it was the other person's fault for what happened here. But very little taking of responsibility by the experienced batterer. And they learn this because they've been through the system, they've been arrested, they've talked to defense attorneys, and sadly enough, in their batterers treatment programs that they attend, they get a lot of stuff out of those too on the side, not by the facilitator, but talking to the other people out there. They're hear a lot of other things that law enforcement looks for in these calls. And that they're going to deny that they did it, that they did not assault the victim. Or in a strangulation case, they're going to deny that they actually squeezed the victim's neck. They just put their hands or their arm there to get their attention. So that's why the question is really so valuable when you ask a victim, when they were squeezing on a scale of 0 to 10, 10 being the worst pressure you can imagine and 0 being nothing, give me a number of what it felt like when they had their arm or their hands around your neck. And when they're telling you it's a high number, that's obviously not the guy who's just got the hands or the arm around the neck to get somebody's attention. Also, you can be asking your suspect, if you're the law enforcement officer making the arrest, about what will the DNA swab show that you took off the victim's neck, as to why his hands were on the neck. Is it going to show touch DNA, his touch DNA on her neck, and see how our suspect responds to that. So we still have a little bit more time. I want to run you through one more case here and have you think about this one. This is another actual case here. So Susan and Bob, they have been they've been dating for 5 years. They've lived together off and on for 4 years. They have 2 children together. There have been several domestic incidences throughout the 5 years, and she reported him to the police 3 times, all of which he was arrested. There is a valid restraining order in place protecting her from him. Despite that, he's been living with her at her mother's home. On this date of this incident, she was in her bedroom getting dressed, and according to her, she was mad and she was giving him an attitude because she was upset with him for not working. So our suspect Bob got mad and he flinched towards her as though he was preparing to hit her, and she responded by slapping his face and pushed him with both hands. So he walked up to her, grabbed her by the neck with both hands, holding her up against the wall, and was squeezing her neck. She felt lightheaded and punched him in the eye, causing swelling. Bob continued to squeeze, but stopped when Susan's mother came into the room. He has a red mark on his face from the slap and redness and swelling to the eye. She has no visible injuries and complains of tenderness to her neck. So here we go again with minor injuries to a strangulation victim and more significant injuries to the other person there. So I'm going to ask you on a poll to think about, if you were the officer there, if you're a police officer, how should the call go? We could arrest nobody and write a report. We could arrest Susan. We could arrest Bob. We could arrest both. So think about that and see what you come up with. Okay, I see some 21 people want to arrest both of them. 12%, they're not going to make an arrest. They're going to write a report only. So basically, when you're not making the arrest, you're just going to rewrite a report. You're going to be saying to everybody, your department, your agency, the court, if it ever went there, anybody that looks at this case, that you could not develop probable cause to believe there was an unlawful assault here. Well, 3 people want to arrest Susan and a lot of people want to arrest Bob. So good call on Bob. Let's walk through some of the significant factors here in this case. So let's look at the history. Remember, that was one of the factors. So there's been several domestic violence incidences throughout the 5 years. She's reported him to the police 3 times. In every of those 3 times, he was arrested. and she got a restraining order for protection. So if we look at the actual assaults, he came up to her and flinched like he was going to hit her. So her response to that was she slapped his face and pushed him with both hands. So think about, what did it mean to her when he flinched? I mean, we have prior domestic violence. Is he the kind of guy that flinches and that's the sign that she's going to get hit? So if that happens every time, that flinch is much more significant than just a flinch and nothing happening. And he grabbed her neck, squeezing, and her response to that was she punched him in the eye. Let's look at the past police reports. And so at the bottom is the most recent, the one we're on now. But let's look at the first call we got, which was a vandalism, where he was jealous because of a new boyfriend the female had. So they were separated at the time. He jumps on her vehicle, causing damage, and he was arrested, and the restraining order was issued at the victim's request. So she actually obtained a 3-year restraining order in December of 2012. Not that 3 months later, the male was invited by our victim with a restraining order to join her and her daughter to go to the park for her birthday. And that's very common. They have a child together. I'm sure she wants the child to be able to see the father. And so that makes a lot of sense. They got into an argument. The female decided to take the male back home, trying to stop, the disturbance at the party. And during the drive back, the male struck the female several times and caused visible injuries, and he gets arrested for, in California, that would be a felony domestic violence arrest here. And then 6 months later, there's a disturbance, both parties hitting and keep kicking each other. So reports made, but the officers who handled this call could not develop probable cause as to if they were unlawfully assaulting each other. And so they did not make an arrest. And then we jump up to 14. The male was found in the vehicle with the female, consensually together in violation of the restraining order, and he got arrested. And our most recent case that we just talked about is they're consensually back together with a restraining order. So in California, just the fact that they're consensually together or she invited him over, that doesn't mean anything. That doesn't change the order. It's still going to be an arrest made because the court recognizes this order says stay 100 yards away, don't contact, and this person intentionally, willfully violated the order. So here's the challenges though. You think this victim will blame herself for the whole entire incident? And she was allowing him to stay even though she had a restraining order. So I'm sure she's going to be thinking about that. She knows she gave him an attitude, and she's the first person that did something. She pushed him, and he's going to be telling her that. What's the defense going to raise if this thing ever did go into court? They're going to say that she assaulted him first. She has a history of assaulting him. Remember the case that there was no arrest. Both people were attacking each other. The defense will use that police report in court to try and convince the court that she is an aggressor. And he has all the injuries. He's the victim, is what the defense is going to raise. So even though we determine dominant aggressor as law enforcement and we make the arrest, there's other issues that are going to continue as the case moves through the system there. So in summary, if you are in law enforcement and you have a function of making an arrest, follow your agency policy. Don't deviate from that because of something that you heard here on this webinar. These are things to think about, things you might want to share with your agency if you need to change your policy, but do not deviate from your agency policy. Don't rush this thing. Take your time when you're trying to figure out who is dominant. Think about bringing in a third party. We always recommend if you have 2 officers on scene and neither one of you can figure it out, maybe call in the sergeant or a supervisor and get a fresh set of eyes on it, a fresh take on it, but don't rush this thing. The big things to look at are history, why people are doing what they're doing, look at self-defense, And if you find new evidence that shows the wrong person has been arrested, be aware of the ways that you can start the release process before this thing gets into the court system. So this really also applies to if you're an advocate working with a victim and major bruising develops later down the road that you know about and law enforcement does not know about, then you need to maybe convince your victim to talk to law enforcement about the new evidence that you have in these cases here. So I thank you for your time, and we've got a little bit of time left for questions.
Okay, so I need to share my screen. Looks like we have no questions right now. People have been really active in the chat feature. So that's going to give me a little time to share my screen.
All right.
And hopefully be able to show solutions. Where'd you go? Where'd it go? Where's my solutions? I think you might need to, let's see, end this show. There we go. And close that. File open. Solutions. There we go. Hit that. Okay. Can you see this, Mike?
No.
All right. Why not? Let's see. Share screen. Solutions. Let's try again. Mike, can you see this?
Yes, you got it.
Okay, great.
You're good.
Then a couple of minutes that we have left, I'm going to try to get us to a couple of things that I think would be important now. As I mentioned, I've been giving a lot of thought to this issue since 1995. In fact, that year I got a call from the coalition. They said, Gail, we're seeing an increase of people being arrested, especially women. Can you write in a short article on this, maybe to help people sort this out? I go, I'm absolutely happy to do that. I go, how many words do I have? They said, you got 500 words. I go, oh, it's going to be easy. Well, when I jumped in, it was not so easy, and I didn't finish until like 30 pages later. So you are going to get a copy of that first article I wrote many years ago. And this has given me the inspiration to go back and update it. So it's a very old article back in the late 1900s. But here's a couple of things that I would do today based on everything I've learned is, what is your law? What is your policy? When was the last time it was updated? Try to figure out who's being arrested. I mean, I tried to search that and I had a hard time. Even asked Grace Schumann, who's part of our team, just got out of law school, passed the bar. So if anybody can find anything, it'd be Grace. And we couldn't find it. We were specifically looking in Virginia. So once you start gathering your intelligence, you can figure out what is the main issue, but always convene your band. Bring everybody back together again. Most of you have a domestic violence counsel or a sexual assault response team. You already are convening people somewhere. Add this to their things to discuss. But I think at the heart of it is making sure our laws and policies are updated, making sure we are providing training. So in my spare time, I teach law school. And in my spare time, I look at all these issues and ask these amazing, talented law students to do some thinking about this themselves. It's always nice to have a fresh kind of look at things from a fresh perspective. And I had one of my students actually write their paper on this. And a couple of things as I was working with him on it, most of our laws are using different terms. I like Mike Agnew's suggestion, dominant aggressor. I asked him, I go, what's your favorite? He goes, dominant aggressor. And I go, me too. I would say, let's add the word strangulation and or suffocation to the statute. That's going to draw attention to it. Let's add all the legal defenses. In California, it just says self-defense. But what about defense of others? What about defense of property? What about ejectment of trespasser? What about necessity? It needs to include all of them. And I think you have to spell out avoiding dual arrest. Are there circumstances where there's probable cause to arrest both? Absolutely. So let me go back to San Diego. When we figured out, oh my, we've got an issue here, I asked our police department, so how many hours are we giving our police officers training in domestic violence? And this represents after many years of advocating for much more. So in some jurisdictions, I'm hearing that police officers only get 2 hours of training. They need more. Prosecutors need more. So here's a mistake I made early on. We worked together to figure out, okay, what training do our police officers need, given that 40% of all the 911 calls are domestic violence related? They're going to need a lot more. So we came up with a course on how to identify the dominant aggressor. At a minimum, I think you need 4 hours, not the hour and a half we're giving you today. So today is kind of like just a teaser, but you need an experienced police officer like Mike to be part of the team. We brought in a doctor, an emergency room doctor, who was really good at identifying offensive and defensive injuries. And I was part of that training team. It's peer-to-peer. The mistake I made after we did all this training, our police officers were doing a fantastic job. I did not include the prosecutors in that training. So they were identifying the dominant aggressor, and then the prosecutors were rejecting the case because it was mutual combat. I go, oh my gosh, that's why I'm a big fan of mutual, multidisciplinary training. Now, most jurisdictions are using these lethality questions. It's called like the Maryland model, the LAP model, and they're asking these questions that I think could be helpful. So take a look at what is happening now. That's that inventory. And I like to remind police officers and prosecutors and all who say, well, some of these jurisdictions that have mandatory arrests essentially eliminate the discretion of police officers. And we were in Colorado doing a 2-day training on strangulation and how to identify the dominant aggressor. Let me tell you, I know it's complicated. And everybody was saying there, you know, there's a reason why we have a high arrest of females, and they had like 25 to 30%. And I think in jurisdictions like those jurisdictions in Connecticut that had the Tracy Thurman case, you know, in Colorado, there was a big national case related to restraining orders, Castle Rock. There is like this concern that you don't want to get it wrong. So you feel like you have to arrest somebody no matter what. But this case came up in a federal court. I should say this issue came up in federal court. And they said, wait a minute, don't forget, cops do have the discretion to determine if there's sufficient probable cause. And part of that is going to base on the credibility of the witness. So that was one point. Then I'd say go to your evidence code, because just about every state has a statute on how do you determine credibility of witnesses. It spells it out. The demeanor, ability to perceive, you know, is there a bias? What's their attitude? Do they have a history of domestic violence? What's their character? And then I'd say follow the evidence, whatever you do. So Mike is one of the best trainers I know, and I just want to highlight some evidence that has helped me and what we're advocating now in strangulation cases. Well, if they deny ever putting any pressure on the victim's neck, I watch NCIS all the time. I'm obsessed with it. And I just see the scene where Gibbs is interviewing the suspect and somebody brings in an envelope with the results of the neck swab. You're not going to be able to deny it, just like swab it. And then I also think in a number of cases we're handling right now, we should have taken the time to like do what they call like a dump of all of the information, text messages, phone, whatever you can from the phone. In a recent case in Texas, in a strangulation case, it was totally appropriate for the police officer to seize the defendant's cell phone at the time of booking and then get a warrant later to download all the information. Y'all know about this, but I'm just going check, friendly reminder. Get those jail calls, your first 3 jail calls after they get arrested, after they get the emergency protection order, they're going to violate it. So you can consider things before the incident happened, and you can also consider things after the incident happened. And those jail calls are gold. And, you know, I love this. Mike was the one that gave me this, and he was the one that taught me this. Always look for notes, cards, letters to and from jail. And this was one from Mike's case where he's doing a follow-up and there's a little note left at the door. I'm sorry for hitting you and leaving this way. You're going to get admissions. And then while we were really big in providing this training, there are lots of tools out there about how you identify the predominant, dominant, or aggressor analysis. It's called like the decision tree. I love the decision tree. And don't forget this. If a victim slaps him first, and then he turns around and strangles the victim, especially to the point of loss of consciousness, urination, or defecation, as Mike pointed out, strangulation is deadly force. You cannot use deadly force in response to non-deadly force. So in this particular case from Missouri, the prosecutor argued the defendant was not entitled to a self-defense instruction because she slapped him and he responded with strangulation. Therefore, he did not have the legal self-defense that he could use. And when he was convicted, he appealed and it was upheld on appeal. I would say Google this. There's a lot of great information out there about how to identify the primary or dominant aggressor. In fact, you can lose yourself in all of these articles. But a really good one is at BWJP, where a former prosecutor wrote a great article about this issue. When battered women fight back, what are you going to do? Very thoughtful. It also has a great appendix where Ellen Pence, who I just love and adore, unfortunately, she's no longer with us, as many of you know, she wrote her thoughts about this issue. And it was fun rereading this again and seeing how much thought they put to it. So don't forget, you gotta join our mailing list. So this way you find out about some of the new things that we're doing. I've got a great, amazing team working with us now at the Institute, and we have all these ideas that we want to do before the end of the year. As a result of COVID, we've had a chance to pivot, and we've had a chance to work on some things we've always wanted to work on. And now we're creating a new compendium for each state related not only to strangulation, mandatory reporting, what is the dominant aggressor law, and write down the list. So each state can have all of the important tools that you need. Because in California, judges have to make this decision too. California judges are not allowed to issue or their mutual restraining orders. And what they have to do, because I just found a couple of cases that went up on appeal, they look to what police officers are doing and how they identify the dominant aggressor. So just like police officers are supposed to avoid it, judges are supposed to avoid it as well for those unintended consequences that Mike talked about. But you also can issue them if you have probable cause to arrest both or probable cause to issue a mutual restraining order. So with all that said, we are out of time. I actually went a little bit over, can't help myself. It's just the way it is, but sign up for our mailing list. We have a lot of fun things coming up, including our FJC annual conference. And we're going to do one more virtual strangulation advanced course in October. And it's going to be 5 Fridays in October. It's actually turned out to be a lot of fun. And people have said that going to the virtual course every Friday gives them something to look forward to, gives them time to process all the information, apply all the information, and then come back and get more information. So I just want to thank Mike Agnew for joining us. His presentation was absolutely impressive as always. A lot of things to think about. I'm going to thank Carly and Grace and our entire team at the Alliance for all of the great work that they're doing. I love and appreciate them all. So thank you for joining us, and hopefully you will join us again for our next webinar. We've got a lot in store. Bye.